Major Supreme Court ruling.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
This case could reshape how far states can restrict your right to carry and where.
Here's something most Americans don't realize. Your Second Amendment rights might require government permission, a stack of paperwork, and hundreds of dollars in fees. But that reality could be about to change forever. Right now, the Supreme Court is reviewing a case that could eliminate every firearm permit system across the United States. Not reform them, not adjust them, completely abolish them. And the decision could come down any day now. This isn't speculation or fear-mongering. This is actually happening. The justices have granted emergency review to a case challenging the fundamental question: can the government force you to ask permission before exercising a constitutional right? The implications are massive, and the stakes have never been higher. So let's dig into what's really going on, why powerful interests are fighting desperately to stop this, and what it could mean for gun rights in America. The permit system itself is under attack, and that's sending shockwaves through state capitals nationwide. Currently, 25 states mandate some form of government-issued license before you can legally carry a firearm. These states collectively process over 3 million permit applications every single year. That's 3 million people having to navigate bureaucratic mazes, pay fees, and wait for government approval to exercise what the Constitution describes as a fundamental right. Now here's where things get interesting. Remember the Bruen decision? That landmark case struck down may-issue systems where government officials could arbitrarily deny permits based on their personal judgment. But Bruen left something intact. It still allowed shall-issue systems to exist. States could still require applications, mandate training courses, collect fees, demand fingerprints, and impose waiting periods, as long as they eventually issued permits to qualified applicants. It was a compromise, and states clung to it like a lifeline. This new case shatters that compromise completely. The legal argument being presented is elegantly simple, yet devastatingly powerful. The Constitution says the right to keep and bear arms shall not be infringed. The plaintiffs argue that any government approval process, no matter how streamlined or fair it appears, constitutes an infringement on that explicitly protected right. Every dollar charged, every form submitted, every minute spent waiting for bureaucratic approval, all of it, they argue, violates constitutional protections that were specifically designed to be absolute. But there's something else driving this fight, something that rarely gets discussed in public debates about gun rights. And when you see the numbers, you'll understand why states are fighting so hard to preserve these systems. We're talking about serious money here. State governments have transformed firearm permits into a revenue generation machine, and the scale is absolutely eye-opening. California pulls in over $75 million annually just from concealed carry permit fees. That number doesn't even include the mandatory training courses that applicants must complete, which typically cost between $150 and $500 per person. Think about that for a moment. That's $75 million flowing into state coffers every year, simply for processing paperwork related to a constitutional right. New York charges $200 just for the application itself. But the real cost? When you add fingerprinting fees, training requirements, and various processing charges, the average New Yorker spends between $400 and $600 just to apply. Not to purchase a firearm, not for ammunition, just for the privilege of applying for permission to exercise a constitutional right. And that doesn't even guarantee approval. Here's where it gets even more troubling. Records obtained through public information requests reveal that many states funnel permit fee revenue directly into general law enforcement budgets. This creates a perverse financial incentive. States now have a monetary reason to maintain these systems regardless of constitutional concerns. It's not about public safety anymore, it's about protecting a revenue stream. And get this, some states actually raised their permit fees immediately after Bruen forced them to stop denying permits arbitrarily. They essentially replaced their lost denial revenue by charging higher fees to the applicants they could no longer reject. The permit system has evolved into what can only be described as a cash cow, and states will do almost anything to protect it. But the money is just one piece of a much larger problem. There's something happening with permit denials that should concern every American, regardless of where they stand on gun rights. Even in shall-issue states, thousands of law-abiding citizens get denied permits every year for reasons that have absolutely nothing to do with public safety or legitimate disqualifying factors. Data obtained through public records requests tells a disturbing story. New Jersey denied approximately 18% of permit applications last year. New Jersey is technically shall issue after Bruen, so why is nearly 1 in 5 applicants being rejected? Maryland's denial rate hovers around 12%, with many applicants denied for allegedly failing to provide sufficient documentation, even when they've submitted everything the state requested. California presents an even stranger picture. Denial rates vary wildly by county. Some counties deny up to 25% of applications, while others deny less than 2%. How does that make sense if the standards are supposedly objective and uniform? The answer is, it doesn't. The system is being manipulated. Here's something that should alarm everyone. Most people who get denied don't appeal because the appeals process can cost thousands of dollars in legal fees. For many Americans, that's simply not financially feasible, so they just give up their constitutional rights, effectively priced out of reach. The data reveals something even more troubling. Permit denials disproportionately impact minorities and low-income applicants. In Illinois, African American applicants are denied at nearly twice the rate of white applicants, even when controlling for criminal history. This isn't about public safety. This is systemic discrimination hiding behind bureaucratic processes. But states have developed an even more insidious strategy for restricting rights without technically denying them. And what's happening right now in multiple states is particularly outrageous. After Bruen forced states to adopt shall-issue systems, anti-gun jurisdictions couldn't deny permits outright anymore, so they developed a new approach. If they can't say no directly, they'll just make people wait so long that exercising your rights becomes practically impossible. It's called administrative delay, and it's being weaponized across the country. Hawaii currently takes an average of 137 days to process a carry permit. That's more than 4 months of waiting. New Jersey averages 92 days despite state law explicitly requiring decisions within 30 days. These aren't accidental backlogs caused by unexpected volume. These are deliberate strategies. Internal emails obtained through Freedom of Information Act requests expose the truth. Some jurisdictions are intentionally understaffing their permit processing divisions to create artificial delays. One email from a California county sheriff's office openly stated they were keeping permit processing staff at minimum levels as a form of resistance to the Bruen decision. They're deliberately denying people their rights through bureaucratic obstruction. It gets worse. Some states implemented new training requirements that must be completed before even applying for a permit. Then they authorized only a handful of instructors statewide, creating waiting lists that stretch for months just to take the required course. It's a perfect trap. They can claim they're not denying anyone while making the process so burdensome that many people simply give up. Speaking of training requirements, that's another area where states have turned reasonable-sounding policies into constitutional nightmares. On the surface, mandatory training sounds perfectly logical. Who could object to ensuring people know how to safely handle firearms? But look at how states have actually implemented these requirements, and a very different picture emerges. Hawaii mandates 16 hours of training before you can even submit an application. The approved course costs $350, and there are only 7 approved instructors in the entire state. 7 instructors for the whole state of Hawaii. California now requires 8 hours of initial training plus 4 hours of renewal training every 2 years. They've made the requirements so hyper-specific that most existing firearms instructors can't teach the approved courses without obtaining additional state certification that costs over $1,000. This isn't about safety. This is about creating barriers. But here's what the actual data shows. Constitutional carry states that have 0 training requirements show virtually identical rates of accidents and incidents involving lawful carriers compared to states with strict training mandates. A comprehensive study comparing crime and accident data found no statistically significant difference in negligent discharge incidents or unlawful use of force by legal carriers between constitutional carry states and permit-required states. Tennessee had a training requirement until 2024 when they eliminated it and adopted constitutional carry. What happened in the first year after removing training requirements? Accidents and incidents involving lawful carriers actually decreased slightly. The evidence strongly suggests that training mandates are security theater designed to discourage people from carrying, not genuine safety measures. All of these barriers, all of these manipulations, all of this resistance points to one fundamental question that the Supreme Court is finally being forced to answer. Can the government require you to obtain permission before exercising a constitutional right? That's the core issue. Every permit system operates on the assumption that you don't have the right to carry until you prove to the government's satisfaction that you deserve their permission. Stop and think about that framework for a moment. Now apply that same framework to any other constitutional right. Imagine needing a First Amendment permit before criticizing the government. You'd have to pay fees, take a class on responsible speech, submit to a background check, and wait months for approval before expressing political opinions. Or picture needing a Fourth Amendment permit before the government recognized your right against unreasonable searches. We would instantly recognize these as unconstitutional infringements. Yet we've normalized treating the Second Amendment as a second-class right where government permission is somehow acceptable. The historical record couldn't be clearer. At the time the Second Amendment was ratified, there were no permit requirements to carry firearms. None. Citizens carried openly or concealed as they saw fit. The notion that you needed government approval would have been viewed as precisely the kind of tyrannical control the founders fought a revolution to escape. Today, 29 states have constitutional carry, proving that permits aren't necessary for public safety. Many of these states have some of the lowest crime rates in the nation while respecting constitutional rights without bureaucratic barriers. The Supreme Court's decision won't just affect permit systems. It's going to define whether the Second Amendment actually means what it says, or whether it's just a suggestion that states can ignore whenever it's convenient. The outcome of this case will fundamentally reshape the landscape of gun rights in America. The balance between state authority and individual liberty hangs in the balance, and whatever the justices decide, millions of Americans will feel the impact immediately. That's it for today, folks. See you in the next video.